This is Law Bites, a podcast with Michael Geist.
But we all know that our online world falls well short of the basic standards that I just mentioned. Bad actors target our most vulnerable, our children. They spread vile hate and encourage impressionable people to commit violence. We know the harms we experience online can have real-world impacts, with tragic, sometimes fatal, consequences. And yet, so much of this goes unchecked. I will explain what C63 will do to make our online world safer, but it is important for Canadians, including the Canadians watching right now, to understand why we are doing this.
That was Justice Minister Arif Irani late last month as the government introduced Bill C63, better known as the Online Harms Act. The bill is the culmination of years of public debate over whether or how the government should establish a regulatory framework for internet platforms in dealing with online harms. The resulting bill is both less and more than anticipated. It's less in the sense that earlier plans to impose website blocking or widespread takedown requirements have been dropped in favor of a more modest regulatory approach premised on a duty to act responsibly. But the bill is also more, as it includes changes to the Criminal Code and the Human Rights Act that have attracted considerable controversy and for which former Chief Justice of the Supreme Court Beverly McLaughlin has suggested that legal challenges are a virtual certainty. There is a lot to grapple with and unpack. To help me do so, I'm joined this week by Vivek Krishnamurthy, an associate professor at the University of Colorado Law School and director of its Samuelson Glushko Technology Law and Policy Clinic. Vivek is a former colleague and director of the Samuelson Glushko Canadian Internet Policy and Public Interest Clinic at the University of Ottawa, and he served as a commissioner on the Canadian Commission on Democratic Expression and was a member of the government's expert panel on online harms. Vivek, it's great to see you again, and thanks so much for joining me on the podcast.
Thank you for inviting me, Michael.
Okay, no, I'm really glad we had the chance to reconnect. We, of course, were colleagues for many, many years, and happy that you've taken the time to come on. Now, there are just so many directions I think that we can take a discussion around Bill C63 in, and I'm hoping that we were able to get into a bunch of them, particularly around the bill itself and some of the happy surprises or the things that I think people have been pretty pleased with, and then also some of the concerns. But I think before we do that, it's useful, and I think pretty important to understand some of the broader context from the bill, and there's several perspectives we could take. I thought, why don't we start with the big one? It's one that I get asked on a number of the podcasts or other kind of appearances that I've had, which is, why do we need this legislation? You know, many say, listen, if we're dealing largely with unlawful content, it's unlawful. And so if there are already rules that deal with some of these issues, why do we need this legislation in the first place?
Sure, that's a great question. So you're right that the law does target a lot of content that's already unlawful under Canadian law. However, the way that the existing law deals with that is mostly through the criminal law and penalizing those who engage in that expression. So we don't have a comprehensive regulatory scheme in Canada that comes to the responsibility of the platforms that host that kind of content. So the way I look at the online harms part of this package is that it's kind of the Canadian version of a global trend of requiring platforms to look at the risks that their business practices and their content moderation and curation methodologies pose, and seek to reduce those risks. So I think that's sort of the core. But there's other pieces like complaints procedure, transparency, regulatory oversight of the platforms, and so on. We can get into that.
Okay, yeah, and we'll get into some of those specifics. You know, what are the platforms doing now? You may have seen that over this past week, I had my own my own incident with one of the platforms, in this case, LinkedIn, where I had posted something about anti-Semitism. It came down, it went back up, it came down again, it went back up again. I have to say that I came away feeling both happy that they were trying to do something and a bit puzzled about just a process that was completely opaque. What in your experience, having looked at many of these issues, what are the platforms doing now, or even better, what are the platforms not doing that really requires, in your mind, or at least in the government's mind, legislative intervention?
So I think there's a wide variety of platforms and a wide variety of responses to the kinds of content that is covered by this bill. So the large mainstream platforms already take action against the 7 kinds of harmful content that are targeted by the bill. We could debate the effectiveness of those measures, but take Meta, for example. Its approach to hateful content is frankly much more expansive than what the bill provides in terms of what their definition of hate is. So if they actually are enforcing that, that means that they're already surpassing the requirements of the legislation. However, the bill does sort of target a large number of platforms, including platforms that are targeted specifically at video streaming and adult content platforms. So we can have a debate, and again, there's a range amongst those platforms, and many of them are integrated with the large social media and tech giants. So there's a great deal of variation there. But I think there's sort of a few pieces here, right? So outside of the approach to content and to defining what's harmful, right, I think there's some measures in the bill that seek to increase the level of transparency and accountability with regard to the content moderation decisions of a wide range of platforms which are covered by the legislation.
That's helpful to understand that that platforms are in fact coming with different approaches, and that this will certainly establish some minimum standards in that regard. In addition to understanding the why one might make the case for legislating, I think it's almost inseparable to understand, well, where have we been in Canada in terms of trying to come up with some sort of legislation on these issues? I focused a bit on this in a podcast just a few weeks ago, where I tried to provide some of the background, but for those that didn't listen to that or want a bit of a refresher, you were intimately involved as part of an expert group. Can you give us a sort of a quick tour of sort of what brought us to this point in terms of Canada's efforts to deal with these issues?
Yeah, so I think this really began in the 2019 Liberal campaign platform, where the Liberal Party promised to enact legislation modeled on Germany's very controversial NetzDG law, which would require takedowns of certain kinds of illegal and harmful content within 24 hours. In 2021, the government was set to introduce online harms legislation. They received a lot of criticism for not consulting ahead of that, so they released a technical paper that was legislation in all but name. And there was a lot of concern, including from the communities that were supposed to be protected by that legislation, over what it bundled in, such as sort of mandatory reporting provisions to law enforcement. So after the 2021 election, where again, the Liberal Party had a platform commitment to do something on this file, the Department of Canadian Heritage appointed an expert advisory panel, which I was a part of. And prior to that, the Public Policy Forum of Canada also had its own process called the Canadian Commission on Democratic Expression, which I served on in its second year. Our former dean, Adam Dodek, was on the first year with many eminent Canadians. And the expert panel did not produce a report. However, a consensus developed around the table that the legislation should not be focused on prompt removal of content, but rather it should be a risk-based approach. So the idea would be to get platforms to look at the risk that they carry and promote various forms of harmful content. We can have a definitional debate on what's harmful, and then work on reducing that risk. And that's an approach that's been pioneered in a number of other jurisdictions, not just on content moderation, but in terms of tech regulation generally, a risk-based approach to regulation. So after some further consultations in 2022 and 2023, we have this bill. And interestingly, it looks like carriage of the file has moved from heritage to justice, which I think is probably for the best, because this is, I think there's many justice equities in this legislative package.
Okay, that's really helpful. you mentioned that this is happening in Canada alongside developments in other countries. So I think that sort of global context is important as well. Can you give us a sense of what are some of the other countries doing? How does Bill C-63 fit within that emerging global framework, such that is this going to look recognizable to tech platforms that operate around the world, or is Canada going to seem like a bit of an outlier?
Yeah, I think there's a lot of borrowing from other approaches around the world. So I think the biggest legislative development is the European Digital Services Act, which is much more comprehensive legislation than what was introduced here. It regulates all kinds of digital intermediaries, right, from shopping sites to social media platforms, and it has many provisions. But the centerpiece of it is this requirement to conduct risk assessments, and that applies with particular force to what are called very large online platforms or very large online search engines. So these companies need to conduct periodic risk assessments regarding illegal content, rights to risks to fundamental rights that their business practices pose, et cetera, and then mitigate those over time. The UK, after a multi-year process, recently enacted the Online Safety Act, which is narrower in focus than the DSA. Again, it's focused really on content. But it introduces a duty of care, which is not dissimilar to what we see in this bill, which requires prompt action against certain kinds of content. But it's in many ways more controversial and expansive, including some really challenging provisions, perhaps around encrypted messaging platforms that we could talk about. Australia has legislation in this field too. And I think some of the procedural aspects around the creation of a digital safety commissioner, we borrowed from the Australian e-safety commissioner. And then I would just say that here in the United States, there's a great deal of legislative activity at the state level around access by children to sexually explicit materials, and actually some rare federal action with the Kids Online Safety Act, which does sort of take a design-based approach to online safety. And that's receiving significant bipartisan support in the Senate right now.
Yeah, that's a super interesting review of what's happening. Particularly, I think the fact that the U.S. is moving as well. The perception often being that it's Europe that has led from a regulatory perspective, and the U.S. that has largely shied away from that. But to see movement there as well suggests that certainly some of the larger players will look at Canada as just part of this global trend and global movement. And so there might not be this outright rejection, but rather more of an examination of how it fits within that global framework. Why don't we get into then some of that framework? It's a really useful background, both in terms of what brought us to this point and what's happening elsewhere. Now, I've described Bill C-63 as almost some ways four bills in one, or you can sort of divide it into two. But regardless, it isn't a single piece of that addresses exactly some of the kinds of issues you've talked about. Can you break down what the component parts are in Bill C-63?
Yeah, I think it is four bills in one. So the centerpiece is the Online Harms Act, which is really directed at platforms, right? Social media companies as defined by the bill. And it creates requirements for those companies, three statutory duties, and as well as new bureaucracies, three separate new entities. Then there was a package of amendments to the criminal code, which have received a lot of attention around hate-motivated offenses. There are amendments to the Canadian Human Rights Act, a reinstatement of the very controversial Section 13, although not in the form that it was in before it was repealed about a decade ago. And then there is provision that requires the mandatory reporting of basically child sexual exploitation material when online intermediaries have actual knowledge that material resides on their platforms.
Okay, we'll leave that last one aside. I don't think that seems to be by far the least controversial. I haven't seen anyone take issue with it. But let's focus first really on the online harms piece, because that's in a sense what most people thought we were going to get with this legislation, and where there's a lot of digging in to do. And then we can, if we've got some time, talk a little bit about what has proven to be quite controversial, as you say, around the criminal code and the Human Rights Act reforms. But first off, It's online harms. What harms are we talking about when it comes to this legislation? And were there any notable exclusions? Are there people who might have expected the government to address certain kinds of harms that walk away saying, "Oh, disappointed that this legislation doesn't touch this or that"?
Yeah, so the legislation, the online harms part of the legislation, focuses on 7 categories of content. So there's non-consensual distribution of imagery known as revenge porn, um, child sexual victimization material, and then some provisions that are aimed at protecting children against self-harm and bullying. And then there's content that either foments hatred, incites violence, or incites violent extremism and terrorism. And as we sort of said at the outset, these are all kinds of content where I think there are relatively fewer constitutional concerns around taking action. But notably, there's a lot of things that are not covered here. So information integrity is not covered. And obviously, that's a big policy topic. I think that's probably for the best because we're still trying to figure out what to do there. And, there's a lot of other kinds of content. So again, there's a focus on material harmful to children. The UK takes a much broader view of what constitutes harmful content. So, for example, modern slavery content is in the UK bill. That's not there. So this is a very focused package when it comes to the kinds of content. And then that's sort of tied with 3 duties. One is a duty to act responsibly that applies to all of those 7 kinds of content, right? And here the duty is to mitigate the risk of exposure. There's a special duty with regard to children, which is to protect them. And there's a reference there to incorporation of age-appropriate design features, which is a borrowing from many other jurisdictions. And then there's a duty to make certain kinds of content inaccessible. So this is the non-consensual distribution of intimate imagery and content that is sexually victimizing of children and adults.
Okay, we're going to jump around a little bit, but just since you closed with this issue of removing those 2 kinds of content, I just want to make sure that to clarify. So that's the only kind of content that's required to be removed. We had earlier proposals that envisioned things like broader takedowns, website blocking, those kinds of things, which certainly attracted a fair amount of criticism. As I understand it, in this bill, it's very narrow in terms of content that would actually be required to be removed under the legislation.
Right. So first of all, there's no general monitoring requirement on platforms to go out and identify things that might fall into these 7 categories of harms. Second, as far as I can see, there's no website blocking mechanism in this legislation. And then third, the categories of content that are subject to this duty of removal is sort of pursuant to a notice and takedown regime, right? So the obligation on the platform to take it down is prompted by user flagging. And then basically a platform needs to make a decision about the user flag within 24 hours, and then the law sets up appellate procedures of various kinds.
Okay, so much more limited with some due process and structure that's built in, which was certainly as part of at least the consultation. There were some concerns that might have been lacking. So if those are the 7 harms and the 3 duties, who does it apply to in terms of the platforms? Can you describe a little bit which platforms or which services on platforms are in, and then which are out, and perhaps particularly the question around messaging services, which I know some people have highlighted to say that is the home for some of the kinds of harms that are identified in the legislation.
Yeah, so these duties apply to what the law calls social media sites, right? Which are websites or applications accessible in Canada, which basically allow their users to access and share content. The law says that, again, adult content sites where users can upload such content and video streaming sites are in, but it says that direct messaging is out. Okay, so we'll have to see exactly what platforms are in and out, and I think some of the technical briefings by the government suggests what will be in and out. But there are provisions in the bill that tie this to basically the size of the platform, the active user base, but which provides a the ability for the regulator to designate certain platforms regardless of their size. Okay. On the messaging, this is a real challenge. It's absolutely true that a lot of very problematic content moves through various kinds of messaging services. The problem here is how do we deal with that without destroying the messaging services in their entirety and their privacy protections? So the UK initially, in its online safety legislation, was considering requiring filtering or monitoring of those services, which couldn't be done while maintaining encryption. And the final statutory text basically makes that subject to a feasibility requirement. But the government, I think, rightly decided not to tackle that issue in this package because it is technically difficult, and I think it raises some much trickier constitutional questions.
Okay, interesting. So that's really helpful in terms of the platforms themselves. Many people have also raised jurisdictional questions, noting that, of course, virtually all of these platforms are not Canadian-based platforms. What's the test or the threshold or the rules around Canadian application of the application of Canadian law to these various platforms?
So I think similar to what we've seen in Europe and the UK, the law says that if the platform is accessible in Canada and either meets the numerical threshold or is designated, it is subject. Now, I think a good way of thinking about this is Peter Swire, who's a scholar of internet law at Georgia Tech, has provided the analogy of elephants and mice. An elephant is large and it can't hide. Meta is very much an elephant, as is Google. So they're clearly going to be subject to this law, and they're subject to Canadian jurisdiction in many other ways. But there are mice, which are small, furtive, hide easily, spread disease, and reproduce quickly. So there's any number of smaller websites which the law might try to scope in, and you can see the regulator trying to say, yes, this is going to apply to platform X. However, enforcement will be very difficult when it comes to those platforms because they have weak jurisdictional ties to Canada.
Okay, thanks. And I assume when you say platform X, you're not talking about X, but
yes,
or Twitter.
Platform Y in that case.
Right. Yeah, it's kind of taken away our ability to use that just as the random example.
That's right.
All right, one last bit on sort of some of the duties. Just wanted to drill down a little bit further on what the platforms actually are required to do. So you talked a little bit about some of the things that they're not required to do in terms of not proactively taking down, for example. But this duty to act responsibly, what does it actually mean from a practical perspective?
Yeah, so we had some debate in the expert panel about whether there should be a defined statutory duty or a common law duty that would evolve over time. And the government has landed on a statutory duty. And as I see it, there's kind of 8 things, right? The first is to take measures that are adequate to mitigate the risk of exposure to the 7 categories of harmful content. And that's sort of keyed to effectiveness, the size of the service, the financial and technical capacity, et cetera. There's a requirement to publish content moderation guidelines and to provide a flagging mechanism so that users can identify the 7 categories of harmful content. Users get or should have the ability to block other users if they would like. So that's a functionality that's required. And platforms are also required to label bots, which is pretty interesting. As far as I know, probably the first legislation that actually expressly requires that anywhere in the world. On the procedural side, platforms have to provide a resource person for complaints to be raised. They need to provide certain kinds of researchers with access to certain kinds of data. But then the big thing is that they need to develop these digital safety plans on some periodic basis that explains how they're going to discharge these statutory duties and then provide metrics on their performance when it comes to reducing the prevalence of the 7 categories of harmful content.
Okay, so I mean, it's interesting. You've done a nice job of breaking all of that down. There's some clear-cut requirements of things they're required to do, and then there's sort of this injection of far more transparency into the system, identifying both, I guess, for the enforcement agency that we're going to talk about in just a sec, and the public as a whole, what it is that they're doing, and then what the data says about a little bit in some ways about the effectiveness of what they're doing and how big the issue is on the platform itself. Why don't we get then to, assuming that's correct, why don't we get then to the issue of the enforcement side, this Digital Safety Commission in particular? Can you describe what it is that, what is the commission? How is it going to be constituted? And there's a lot there, but if you want to just highlight what you think the most relevant aspects of it are.
Yeah, sure. So I think there's three new institutions that are created: an ombudsman, a digital safety commission, and then a digital safety office that supports both of those, the commission and the ombuds. So let's talk about the commission. The commission has pretty vast powers, right? So it receives the digital safety plans, reviews them, and that includes obligation on platforms to provide these inventories of data that are relevant to the safety plans. There's a function where the public can basically complain about how platforms are dealing with anything covered by the law, but specific power when it comes to the kinds of content that are subject to the duty of removal. So the non-consensual intimate imagery and the sexual victimization content, right? And then the commission gets to adjudicate that and basically look if the platform has reached a correct decision. But then it has some very, very vast powers to enforce the act. It can summon witnesses, it can designate inspectors. Those inspectors can go into any place and access any document or computer that they believe is relevant to the compliance or non-compliance determination with regard to the provisions of the act. And then they can, issue some pretty hefty administrative monetary penalties, right? Depending on the category of violation, 6, 7, or 8% of global revenue. So those are the powers. But there's a provision that really bothers me, which is that the commission is not bound by rules of evidence. And in fact, the statute says it has to deal with all matters that come before it as informally and expeditiously as possible. I think this is a recipe for potential disaster. These are extraordinarily vast powers, which are coupled with some very significant penalties. And when you put those two things together, and again, the commission, unlike some other legislation, right, where we might have an investigative commissioner and then a tribunal or the courts determine basically whether an offense has occurred and what the penalty is, this commission does everything. So I think that is an area where we need to have a serious debate about whether that is the appropriate enforcement structure for this legislation.
Yeah, no, I completely agree. I had flagged that issue, and I must admit, with great power, it seems to me, comes great responsibility. There's great power there, and the idea that you would sort of junk rules of evidence to say, well, we just want to get on with this as quickly as possible, is frankly strikes me as madness. I don't quite understand it. My own view is that this is a bill that is really going to require quite a lot of public trust and confidence, and it's going to be based, that trust, if it is going to come not just from the bill and the harms that are identified, but very much in how it's enforced from this commission. And to give it these kinds of powers, I think, really risks the ability to generate or garner the kind of trust that the public as a whole needs. How do you see this ultimately playing out in terms of sort of we've got the platforms that are looped in and their responsibilities. You've identified a whole series of investigative powers. When do you think kind of the rubber hits the road in that context? Because a bunch of the stuff that you talked about, whether that's the requirements to allow people to mute or to identify, to flag content, and then of course develop this digital safety plan, that puts it on the platforms themselves. Do you envision that these powers come to bear once the digital safety plans are in and the commission takes the approach of saying, well, we're not going to take your word for it, we're going to go in and do all this? Or is it more once there are complaints that arise saying that they've got this plan, people are saying they're not living up to the standards, and the commission decides to investigate? How do you see some of this playing out?
Yeah, I think it's hard to tell how exactly this plays out. I think some of these questions will be addressed by regulations, right? That's one thing, and there'll be an implementation period and phasing in. However, practically, I think there's a few things. So let's bring in the ombudsperson here for a moment,
Yep.
which is that there is an ombudsperson set up, but the powers are pretty ill-defined. I think that once the ombuds is stood up, that people will probably go, right, to the extent that they want some help. It'll be interesting to see when exactly the platforms will be subject to the requirement of having a contact person in place and of architecting some of these technical features like flagging, for example, right? However, I think a lot of it is going to depend on the approach that the commission takes to exercising its powers. And here's where I see one notable omission from this bill as compared to some international peers, which is that there were no code of conduct provisions, which I found kind of striking. So a lot of digital regulation, and this includes the sort of PIPEDA reform, provides for the creation of codes that help platforms and those who are subject to the regulatory requirements understand what they should do in order to generally be compliant, right? And those can be created by industry and then blessed by the regulator. This legislative package, as it currently stands, does not include that provision. And I think that would be a very useful addition, precisely for those transitional reasons, right? Which is that we can sort of align expectations in that implementation period and maybe improve the situation faster than if we had to use an enforcement-based approach.
Okay. Are there any other you've highlighted a few areas already for improvement on this aspect of the bill? Anything else that immediately strikes you as requiring deeper study or potentially reform?
Yeah, I think the investigative provisions are pretty problematic. I think that requires a lot of thought, and this is not the only bill that has those kinds of provisions, but I think in the context of platforms that deal with a great deal of private information, it could be especially problematic. I think we've talked about the informality of procedure. While I'm a researcher and I like research access to data, I think we need to have a conversation about that as well. It's very important that researchers get access to data so that we understand the moderation practices and we can assess what works and what doesn't. However, Cambridge Analytica started as a data access scandal. And I'm a little struck by the fact that throughout the bill, there's no borrowing of other sites of expertise within the federal government in helping set this up. The Privacy Commissioner has a lot of expertise on a lot of things that are covered by this bill. So does the Tri-Council when it comes to research specifically. And I think it would be interesting to leverage some of the expertise that resides in other parts of the government to help administer many of the provisions that we're seeing in the Online Harms Act.
Okay. There's some really interesting suggestions. So you've identified some ways that we could fix or certainly get into a debate about improving the online harms piece. Let's quickly turn to the Criminal Code and Human Rights Act reforms, because those in many ways have attracted the lion's share of attention, at least so far in the media and in social media discussion around the bill. My sense in some of the discussions that I've had is that there's there is a blurring that has taken place in the minds of many, where the kinds of discussion around those provisions are being imputed to the legislation as a whole. And that's, I think, in some ways undermining not just support for the bill, but real confidence and raising a lot of concerns. Can you quickly take us through what does the government envision? What does it propose with respect to the Criminal Code and the Human Rights Act? And then we can get into why that has sparked the kind of concern that it has.
Yeah, so there's a number of sort of housekeeping criminal code amendments, but the two big ones that I want to focus on are this idea that any hate-motivated offense could be subject to a maximum sentence of life imprisonment, and then what I'll call the prior restraint provision, which allows for someone who has a reasonable apprehension that someone's going to commit a hate offense can go and essentially obtain a recognizance with the permission of the Attorney General, requiring that person to basically engage in good behavior for a specified period of time. The criminal code provision on the hate, let's call it the hate sentencing enhancement, in my mind, is extraordinarily overbroad. It covers not just all criminal code offenses, but any offense under any act of parliament. And, we have a lot of interesting laws in this country. There's a Fertilizer Act, and the Fertilizer Act makes it an offense to sell unregulated fertilizers in this country and to prevent inspectors from inspecting your fertilizer. If someone violates that law motivated by hate, is life imprisonment an appropriate and proportionate penalty? Now, of course, I don't think any court in this country is actually going to impose that. But we have to be very careful in drafting criminal law. I think it's very important that sentences are proportionate to the offense. So, there's a lot of nonviolent offenses in the criminal code. Drug distribution, fraud, right, is a criminal offense. So you defraud someone motivated by hatred. I'm not sure that life imprisonment is the appropriate maximum. So we can have a debate about whether some of those nonviolent offenses, if they're motivated by hate, should be subject to an enhancement and what that enhancement should be. But it seems to me that outside of violent offenses, a theoretical sentencing enhancement that goes up to life is really too much. And again, I know that the government has been trying to clarify the meaning of this, but just look at the text, right? The text of the law is the text of the law. And I think it behooves the government to be precise in its legislative language. And this is something we've seen across a number of digital policy bills that have been introduced in recent years, that the statutory text is vast and capacious. And then, there's either a trust us, a call to trust the government and or regulatory walking back of some of that. But I think this is a bad way of doing legislation.
That's the criminal side. Can you touch a little bit on the Human Rights Act provisions as well?
So the Human Rights Act amendments basically restore the very controversial Section 13, albeit in a narrower form. So the previous Section 13 made it a discriminatory practice to engage in expression over, let's call it telecommunications, that were likely to expose persons to hatred. Now the standard has been tightened to hate speech that is likely to foment detestation and vilification. So that's a narrowing. I am not sure, however, that the Canadian Human Rights Commission and Tribunal are the right place to deal with this kind of societal problem. So human rights legislation in Canada is focused on discriminatory practices. And I think we have a common sense understanding that of employment or housing discrimination, right? Or you're at a restaurant and someone doesn't serve you because of the color of your skin or pregnancy, whatever, right? And there's a certain kind of discriminatory effect that you experience in those settings. And I'm not sure that the exposure to hateful expression, although it's terrible, is the same kind of thing, and that the approach of the tribunal. So the tribunal's remedies are to provide cash compensation to a victim of discrimination and to levy fines. And, I think that when we're dealing with hateful expression, I'm not sure that penalizing it is the right way to go about it. I think it would be much more powerful if we could devise tools that change people's views. And this is where, there's some interesting academic research on the use of restorative justice techniques in this field, right? Actually getting the person who said something hateful in the same room in a non-confrontational way with the people who are hurt and trying to achieve some other kind of resolution, right? I think that would be, I mean, it's just one approach. But to me, this part of the legislation, it's interesting that the government did not consult, as far as I know, on these amendments as widely as it did on the online harms package. And I wonder if we had rich consultation, if we would have seen, other ideas develop that might have been better placed. But again, it's become intensely controversial because Section 13 was very controversial in the late 2000s and early 2010s. And again, I feel like this is distracting us from the policy conversation that we really need to have on the online harms provisions of this bill.
That's a terrific analysis of both what's there and why it's raised concerns. You mentioned that there had not been a lot of consultation on this. One of the things that strikes me about, especially the online harms piece, is that, frankly, unlike some of the other forays the government has had into internet regulation, C11 and C18, which felt driven largely by lobbyists or stakeholder interest as opposed to public consultation and public policy development, that the online harms piece is much more closely aligned with a true policy development and particularly the expert panel that you were a part of. I'm curious, did the expert panel, and I know there aren't specific recommendations, it was more just discussion and notes on what was discussed. To what extent did these last pieces, the criminal code provisions and the Human Rights Commission, come up as part of a discussion? And were there any sort of recommendations or consensus around inclusion of those kinds of provisions?
To the best of my memory, I don't recall a discussion about the Human Rights Commission. I do recall some discussion regarding sort of the criminal law power more generally, but I think the focus of our work, and listeners can look at the reports of the expert panel in case my memory is faulty, which it probably is. But we really focused on systemic issues, right? I think everyone had a view that trying to target particular pieces of content or particular bad actors wasn't the way to go, right? That we're trying to reduce the overall harm, yet provide remedy to people who have been harmed. But I think the focus of our conversation was really around remedial action by the intermediaries rather than going after the particular people who engage in hate.
Okay. Well, it must feel at least somewhat gratifying, I would think a lot gratifying, to know that you participated in that process and to see some of that work directly reflected in government legislation. So, so thank you for the work that you and the panel as a whole did, because clearly it had a pretty significant impact in improving the legislation. And thank you for taking the time to come on and I think really expertly breaking down what's in the legislation and ensuring that, as this proceeds, people will have some of the tools and the knowledge they need to actively participate.
Well, thank you, Michael. It's such a pleasure to come on, and always a pleasure to speak with you.
That's the Law Bites podcast for this week. If you have comments, suggestions, or other feedback, write to lawbites@pobox.com. Follow the podcast on Twitter @LawBitesPod or Michael Geist @mgeist. You can download the latest episodes from my website at michaelgeist.ca or subscribe via RSS at Apple Podcast, Google, or Spotify. The Law Bites podcast is produced by Gerardo Lebron Laboy. Music by the Laboy brothers, Gerardo and Jose Lebron Laboy. Credit information for the clips featured in this podcast can be found in the show notes for this episode at michaelgeist.ca. I'm Michael Geist. Thanks for listening, and see you next time.